Okay, good afternoon. You ready to go?
Good afternoon, Your Honor. May it please the court, my name is Heather DeGrave on behalf of the appellant Audrey A. Bryan, and I would like to reserve 5 minutes for rebuttal.
Sure.
To put this in context, we're here today because before my client, Ms. Bryan, filed her petition to determine intestate beneficiaries, Ms. Bryan and her sisters and brother had been entirely excluded from distribution of their mother's estate. When Mr. John opened the probate proceedings, he named himself as the surviving spouse and only known beneficiary, when he knew all of Ms. Malcolm's children and knowingly failed to tell the court of their existence. Appellees did not notify Ms. Bryan or her siblings of the administration of the estate or of their right to inherit, and Ms. Bryan and her siblings did not find out until after Mr. John had taken all of the cash assets of the estate for himself. Those are long gone. In fact, Mr. John should not have received any distribution at all because he and Ms. Malcolm were never validly married. Now, in the prior appeal in this matter, Bryan v. Fernald, which is cited at 211 Southern 3rd 333, this appellate court gave the trial court a clear directive: engage in an independent analysis of whether the marriage was valid under the applicable law. However, the trial court failed to conduct that independent analysis. Instead, the trial court applied an incorrect standard of proof, overlooked the fact that Ms. Malcolm had used a stolen identity to obtain the purported marriage certificate, overlooked the evidence that Ms. Malcolm had held herself out as a single woman in multiple official documents years after the purported marriage, and improperly considered the evidence regarding non-party Dr. Plantz's involvement in the litigation. First, the order determining beneficiaries should be reversed because the trial court applied the incorrect standard of proof. In the oral pronouncement of her judgment, the trial court stated that appellant had failed to establish intent to defraud or purpose or motivation for Venetia Malcolm John in the marriage certificate. But as appellant's counsel made clear in closing argument, and those points can be found at record pages 755 through 56, 761, and 786. The standard was whether Ms. Malcolm used the name Golene Davis for an honest purpose. In Massachusetts, the first step to have a valid marriage is to complete under oath an application for marriage called a notice of intention to marry. That application contains information important to the state registrar of vital records and statistics, including the name, the birth date, and the parents' names. And the name,
Grave,
yes.
Mr. Grave, doesn't the fraud have to go to the very essence of the marriage, not just some other fraud or dishonest purpose?
Well, don't
the cases say that that's what it's looking at, the core of the marriage itself?
I think two things, Your Honor. I think that first of all, the standard on whether this was a validly completed notice of intention is whether the name is used for an honest purpose. With respect to the question of fraud, there is case law that says that being defrauded has to go to the nature of the marriage. But the point is that the notice of intention to marriage is a legal document that's completed under oath. And the
document here is the application. Because yes, was that admitted properly?
Your Honor, the application for marriage was not admitted. However, the marriage certificate, which included the information from the application for marriage, was admitted at the trial level. And it included an incorrect name, which we can get to in a minute, but it also included names information that is obviously inaccurate as to Ms. Malcolm, the birth date and the names of the parents, which were obviously the information of a real person named Golene Davis.
But here the testimony, even from her children, were that they seemed like they had a valid marriage. They were married for a period of time. Their intention was to marry each other. And I mean, I think there's even cases, I think it's the Chipman case that talks about a false name that was used. And as long as the intention is to marry each other, you know, I don't know how we don't find that the marriage here was valid. I understand the argument about that there are reasons why she had this alias name, and other reasons to defraud and use the alias to obtain money and property or whatnot. But I don't see how that is going to the very essence of the marriage here.
Well, first of all, with respect to the testimony of the children, as this appellate court said in the prior appeal, they were just testifying that they had witnessed a ceremony, but that they did not know whether it was legally binding as a marriage. So that the court needed to engage in an independent analysis, regardless of the testimony of the children with respect to that. With respect to the intent to be married,
well, let me back you up just a moment. Yeah. And do we not then defer to the trial court's findings as to that part of what the court was required to do on remand?
I think the standard is clear error. It is a higher standard than de novo, of course. But I think that when you look at the evidence, I don't see how a reasonable court could have interpreted the evidence. Specifically, what you see is even after the purported marriage, Venetia Malcolm is continuing in multiple documents over multiple years, holding herself out as a single woman. Golene Davis may be one thing, but Venetia Malcolm is holding herself out as a single woman, including in tax returns filed with the state of Massachusetts. So the state of Massachusetts, with the same state where she completed this marriage certificate in the name and biographical information of Golene Davis, a real person whose identity she used. In that same state, she is also separately filing tax returns where she is identifying herself as a single woman. And that is in the years immediately following this purported marriage. So she is not holding herself out as a married woman when she's taking the name Venetia Malcolm. She's holding herself out as a single woman in documents filed with the state of Massachusetts, while also filing as Golene Davis, a married woman. So it's not that there was so there was a stolen identity that was used to obtain credit in two names, obtain property in two names, acquire property and incur debt in two different names and two different marital statuses, and also to acquire social security numbers and the benefits that go along with that. That's what this was for.
So then would you concede here then that any fraud or dishonest purpose wasn't to the husband here, but was to other third parties?
I would say that the fraud perhaps was not to the husband. However, when you talk about the essence of the marriage, you're also talking about, were they really intending to be a married couple with all of the religious, cultural, legal status that goes along with that, or was she along with Mr. John creating this identity of a married woman so that she could acquire property in both her name as a single woman and in another woman's name as a married woman. So that still goes to, I think, a fraud as to the essence of the marriage, even if it's not a fraud on Mr. John himself.
Well, but from what you're saying, it almost sounds like there's some sort of concerted effort on both of them. So that wouldn't necessarily be a fraud on him. I guess what you just described seemed more like a concerted effort, together, I guess, as co-conspirators or conspirators, if you would.
Frankly, Your Honor, I don't disagree. I don't disagree with that analysis. I think that the when you look at how we got here in the first place, which was that my clients were intentionally excluded, and even though Mr. John
But that's not
knew them,
right. But that's not before us. That's not that issue isn't before us.
I understand, Your Honor, but I think that when you're looking at yes, yes, I don't disagree with Your Honor's analysis that I think that Mr. John was not a good actor in this case, but the question is that was this a valid marriage, and when it's obtained by using a stolen identity to complete a marriage application, is it really about the marriage, or is it really about creating an identity to obtain property in two different names, obtain debt in two different names? That's not a valid or honest purpose for using the assumed name. This is not an instance of an assumed name. It's an instance of a stolen identity.
So are there any cases that you can point to with what your position is, that these two were either acting together for a fraudulent purpose to defraud other people with the marriage? Is there any cases that are similar to that?
Your Honor, the cases that we cited were the ones that we
so nothing similar to that factual scenario.
I would agree, Your Honor, and I don't know if it's just a matter of that the courts haven't seen that before or what, but the issue was that but when you look at the cases that involve assumed names for an honest purpose, it's situations like somebody having multiple surnames because of their culture, and then deciding to identify under one surname, or situations where immigrants with names that are not as easy to pronounce in the English language decide to take on an English sounding name when they arrive at the country. Those are the kinds of assumed names that you see, not using a stolen identity. That's just a different matter entirely, because it's not just using the name. It's also, like I said, using a birth date that is the birth date not of Ms. Malcolm, but of this real woman, Golene Davis, and not just the and the names of her parents, not Ms. Malcolm's parents. It's not just using an assumed name.
Okay, and the husband here was aware of the assumed name.
Your Honor, I don't know that was ever determined one way or the other, whether at the time of the marriage he was aware of the assumed nature of the name.
Okay, but after.
Right. Obviously, by the time of this trial, he was well aware. Ms. Malcolm used the stolen identity and the resulting invalid marriage certificate to obtain multiple Social Security numbers, to live in the same home but use two different names, to obtain credit using two different names, to obtain property using two different names and two different marital statuses. And then in the years following, she acquired a home as a single woman, and it was not the same home where Mr. John was residing. She took out a mortgage as a single woman. She released the mortgage as a single woman. She obtained another mortgage as a single person. She filled out an application for a mortgage to a federally insured bank, and she swore under oath that she was a single person. She attached to that application an income tax return, and this is the state of Massachusetts income tax return that identifies her as a single woman years after she purportedly married as Golene Davis. She did not believe herself to be legally married to Mr. John. The only reasonable interpretation of these documents is that she did not actually believe herself to be legally married to Mr. John. And so the trial court clearly erred in its analysis of the evidence, and the order determining beneficiaries should be reversed. Finally, it was clear from the trial court's remarks during her oral pronouncement of her ruling that she allowed the evidence regarding Dr. Scott Plance's involvement to color her analysis of the case. And it was improper for her to consider this, but the words that she used in her closing remarks included venom, vitriol, hijacking the family, destroying the family. These were comments that she made about Dr. Plants, even though Dr. Plants was not a party and he did not even testify at the trial. There was no reason for her to bring up these remarks except to reveal that she allowed this evidence, which was not relevant to the very narrow issue that was being tried, to allow it to color her opinion of the entire case and to overlook the fact that my clients had been completely excluded because of Mr. John's knowing failure to identify them as beneficiaries. So, Your Honors, I'll reserve the rest of my time for rebuttal, but I ask that the court reverse the order determining beneficiaries and remand to the trial court with directions to enter an order finding that Mr. John is not the surviving spouse of Ms. Malcolm.
Thank you, Ms. Grave. Mr. Cummings?
Thank you, Your Honor. May it please the court, good afternoon. My name is Sean Cummings on behalf of the appellees. Your Honors, as Judge Smith points out, the Supreme Judicial Court of Massachusetts, which is the Supreme Court in Massachusetts, explained what's necessary to invalidate a marriage under Massachusetts law, which is, by the way, the only issue on appeal, is whether or not the marriage between Edward John and Venetia John is a valid marriage. And what the Massachusetts Supreme Court said is the following: a marriage will not be invalidated unless there is deception going to the very essence of the marriage, which prevents the spouse from performing the duties which law and custom impose upon a husband or a wife. So it's a two-part test. First, there has to be deception that does go to the essence of the marriage. And then second, the deception must prevent the party from performing their marital duties. That's the test for invalidation of a marriage under Massachusetts law. That rule was announced in 1921 in the case of Chipman versus Johnson. It's found at 237 Massachusetts 502. That test has not been altered since that time. It is still the rule of law that applies in Massachusetts today. So that's the applicable law. The facts of that case are also instructive for our purposes, because in that case, a husband used an assumed name, and he did so specifically to conceal his true identity from his wife. He lied about where he lived. He lied about his social status, his economic status, his family ties, a lot of things. And the couple had a ceremony. They exchanged vows. They actually stood across the aisle from each other and married the human being to whom they intended to get married. That was important. They cohabitated for 1 week. And then the husband completely disappeared. And when the wife learned about those deceptions, those misleading facts, she moved to invalidate the marriage. The Supreme Court of Massachusetts refused. It explained that the allegations of deception that I just went over, first, did not go to the essence of that marriage. And then second, even if they did, there was nothing about it which impeded the ability of either spouse to perform the marital duties. And so invalidation of that marriage was not proper under Massachusetts law. And one of the things that the Supreme Court focused on is it the human being that the spouse intended to marry? If so, it's a valid marriage under Massachusetts law, so long as it's solemnized as according to the rest of the statutes. So when we apply that rule of law and those facts to the marriage between Edward John and Venetia John, it becomes pretty clear why the trial court held here that the appellants could not meet the evidentiary burden of proof required to invalidate this marriage. So the first prong of that two-part test is deception that goes to the essence of the marriage. First of all, as Mr. Grave conceded, there is no evidence in this record that shows any deception between the spouses, between Mr. John and Venetia John. In fact, the record does show that Mr. John knew Venetia John used an assumed name during the wedding. In fact, the entire wedding ceremony was carried out using her assumed name. He also testified, it's in the record, that he was aware that she had used different names since coming to the United States. And by the way, the appellant herself, Ms. Bryan, as well as the rest of the siblings, also acknowledged that fact as well. So this wasn't a secret. Everybody knew that Venetia John used different names, which is completely allowable under Massachusetts law. So instead of showing any deception that goes to the essence of the marriage, which is what would be required, what appellants have done is sort of make these allegations. There's really two different sets of allegations to show that there was some type of dishonest purpose or deception. The first one is that Ms. John used a different name and other information on her marriage application. And then the second part is this idea about her buying property as a single person, which, by the way, occurred 8 years after the occurrence of this marriage. So absolutely nothing to do with the time period of the actual marriage. But regarding the first one, all we have to do is look at Chapter 207, Section 52 of Massachusetts General Law. And it says, I'm quoting, whoever violates any provision of Section 20, and Section 20 of this chapter is the one requiring the marriage application. It lays out the requirements of the notice of intent to marry. So it says, whoever violates any provision of Section 20 and whoever falsely swears or affirms in making any statement required under Section 20 shall be punished by a fine of not more than $100, period. That's the entire remedy. So even if we were, and by the way, this issue about her stolen identity and all this dishonest, we completely contest that. It's a hotly disputed issue. But even if we were to accept the appellant's assertions in that regard, the allegations that there's some issue with the way she filled out the application, the entire remedy under Massachusetts law is a fine of $100. Not even close to invalidation of this marriage. It just doesn't get there. It's a $100 fine at most. Regarding the second second set of allegations of deception goes to disowning property as a single person. First of all, absolutely no proof in the record that there was anything dishonest or deceiving about that conduct. Could very well have been that Ms. John decided to own property outside of a marital asset, that she wanted to own that property as an individual. Could be that there was some type of loss in communication in achieving that process. The point is, there's no proof that it was a dishonest purpose or any type of deception that goes to the marriage. That's innuendos and speculation, no proof. But even if we were to assume that those things were done somehow improper, still doesn't go to the essence of the marriage. We're talking about buying and selling property 8 years after the occurrence of this marriage. And if you can't point to the deception that goes to the essence of the marriage, as Judge Smith put it out, then that is absolutely not grounds for invalidation of a marriage under Massachusetts law. You just don't get there. So then we look at the second prong of the Chipman test. The first part is deception that goes to the essence of the marriage. We don't have it. The second prong is if there is deception, it has to impair the abilities of the spouses to perform the marital duties. And this one I think is probably even easier for the court to figure out because Mr. and Mrs. John lived together, cohabitated, held themselves out as a married couple for the entirety of their 13-year marriage. And that's testimony from the appellant, Ms. Bryan, as well as the other siblings. They all said, yes, we believe that our mom was validly married to Edward John. They cohabitated for the entire 13 years that they were married until her death in 2007 for medical negligence. That they held themselves out as a married couple to anybody else who was looking. So they in fact performed the duties of the marriage that law and custom impose. So there's absolutely no evidence at all on the record that either one of these two people couldn't perform the marital duties imposed upon them by law and by custom. And so appellants fail on both prongs. The Chipman test, which is the actual law that applies, requires both prongs be met. Neither one was met. And that's why the trial court in this case said that the appellant failed to meet the evidentiary burden of proof to establish her claim that the marriage was invalid. So that was the right decision by the trial court, and this court should affirm it. And that the argument could really stop right there. That's really all this court needs to decide this case. You apply the law that's established in Chipman. Factually, the appellants can't meet those two prongs, and the case is over. That's the decision. This marriage should not be invalidated. But what I do want to take a few minutes and do is talk about the appellant's proposed test. It's what I'll call the dishonest purpose test, which is kind of the test that the appellants have fashioned to try to get the courts to invalidate this otherwise completely valid marriage. And what the appellants argue is that if you use an assumed name, and then at some point, any point, by the way, throughout the entire duration of the marriage, you can show some dishonest purpose, then the remedy is to invalidate a marriage. And they fashioned that test from a case called Petition of Marylevitz. That's where it starts. That case, by the way, has nothing at all to do with marriage. It's a case about a petition. Mr. Marylevitz wanted to change his name. So he petitioned the court to officially change his name in the court records. The court pointed out during that process that a person in Massachusetts can use an assumed name for almost any purpose at all in Massachusetts, including marriage. All kinds of business purposes. There's a whole list of things for almost any purpose, but you have to do it for an honest purpose. And that is still the law in Massachusetts. That's still good law, but it has nothing to do with invalidation of a marriage. So the question then becomes, well, how do appellants get from the premise that a person can use a name as long as it's for an honest purpose to their suggested remedy, which is if you can show a dishonest purpose, then the remedy is invalidation of a otherwise valid marriage? How they get there? And to get there, appellants cite a CLE article on gay marriage. And I briefed this a little bit in the answer brief. The proposition that they use is an opinion that is offered by the author of that CLE article. And the author basically says that outsiders, meaning not the spouses involved in the marriage, but outsiders, quote, may challenge the validity of a marriage where the marriage is based on a false pretense on the application. The false pretense, by the way, in this author's CLE article was talking about same-sex marriage applicants who misrepresent their home state. These are non-residents of Massachusetts. They lie about their home state, and they do it for the purpose of skirting their home state's same-sex marriage laws so they could go to Massachusetts and get married because Massachusetts allowed at the time same-sex marriage. And the author of that CLE article says, look, if you misrepresent your home state, your state of residence, for the purpose of getting around their laws, then outsiders may challenge the validity of the marriage. And that's how they got to this argument that the remedy is invalidation of the marriage. But there's two glaring problems. First and foremost, it's a CLE article, and it's an opinion within it. There's absolutely no authoritative element to it. And in fact, the opinion part of it isn't even cited with any authority. It's literally just the opinion of the article, of the article's author. Second, even if you were to consider it authoritative, the article does not say that the remedy is invalidation. It says that outsiders may challenge it, but it stops there. It doesn't even say what the potential result of any such challenge would be, and it certainly doesn't say that the result would be invalidation of a marriage. So even if we were to adopt this non-authoritative CLE article on same-sex marriage, it still doesn't get us to invalidation of marriage as the remedy as the appellants propose. So their dishonest purpose test still doesn't come with the remedy that the appellants are asking this court to impose. And in fact, there's law that says the exact opposite. It's a Florida case. There wasn't a Massachusetts case right on point, but the Florida case addresses what it calls the general rule throughout the country. So it's worth looking at. The case is Metropolitan Dade County versus Shelton. It's 375 Southern 2nd 32. It's a fourth DCA case issued in 1997. That case was talking about, well, what happens if two people get married, but the marriage license is somehow defective? And the court noted there's no Florida precedent right on point, so it looked to laws around the country. And this is what the rule says. I'm quoting, the general rule throughout the country is that an invalid marriage license does not of itself invalidate the marriage in the absence of a statutory declaration of invalidity. So that's the rule. So in other words, even if you have a problem with the marriage application, which is what appellant is arguing here, that unless there's some statutory declaration that says what the remedy is, and that remedy is invalidation of the marriage, then the general rule is that a marriage is not invalidated based on that problem. And that takes us again back to then, so what are the statutory declarations in Massachusetts that would apply? Well, first we go back again to Chapter 207, Section 52. That is the actual remedy. That's the one that I read earlier that says the remedy is a $100 fine. Nothing about invalidation of a marriage. If you've got a problem, even if you falsely swear or affirm in making statements on the marriage application, then you have a $100 fine. So that's the remedy. There's also just kind of guidance, Chapter 207, Section 42. It's also helpful. It says that a marriage solemnized by a person with authority shall not be void, nor shall the validity thereof be in any way affected by an omission or by informality in the manner of filing the notice of intention. If the marriage is in other respects lawful and is consummated with a full belief of either of the persons so married that they have been lawfully married. So those are the two statutory declarations that are really kind of on point under Massachusetts law. And it says that if you're married, if your marriage is solemnized, which this one was, there was a full wedding ceremony with a preacher who, by the way, gave everybody in the audience an opportunity to object, including the petitioner. Nobody objected to this wedding. And if either one of the parties believed they were legally married, then your marriage is not void or voidable under Section 42, Chapter 207 of Massachusetts law. At most, if you misrepresented a fact on a marriage application, you owe Massachusetts a $100 fine, and then you go on about your business as a married couple. So that is the statutory declaration in Massachusetts that guides this case. So the point of all of that, look, we don't disagree at all with this dishonest purpose test. That's not the test. The test is under Chipman that I talked about when I first got started. But even if the dishonest purpose test were to apply, and even if the appellants could put forth some evidence, which they cannot, actual proof of dishonesty or deception, they still don't get to the remedy of invalidation of this marriage because there's no statutory declaration that gives them that remedy. It just isn't provided for under Massachusetts law. So there is no authority, whether it's under Chipman or whether it's under this sort of fabricated dishonest purpose test, which gives appellants the authority to invalidate this marriage. And that's what the trial court said. It said the trial court, first of all, didn't accept the test proposed by the appellants, and then said factually they weren't able to meet their evidentiary burden of proof to substantiate it. So appellants lose really under either test. I want to spend just a few minutes. I've got about 3 minutes left. I do want to spend just a minute talking about an issue. It was in the initial brief heavily. I think I heard Mr. Graves say at the beginning about the improper standard that was applied. Wasn't in the reply brief at all. And that's the appellant's argument that the court applied the wrong standard because in its order, it referred to an intent to defraud. First of all, to be entirely clear, the trial court never said that the standard that the appellant had to prove was fraud. It didn't say that. The actual order says this. It says petitioner, who now is the appellant, petitioner failed to meet the evidentiary burden of proof required by her argument that the decedent had engaged in an intent to defraud. So what the court was doing was reiterating what the appellant's argument was to the court, which makes total sense when you go back and look at the papers. I cited it in the brief. I won't go through them again, but all through the motions and the petition to the court, in the opening statement, throughout the presentation of evidence and the closing arguments, the petitioner repeatedly said to the court, invalidate this marriage because of fraud. And so it shouldn't be a shock to anybody when the trial court said that the appellant didn't meet its burden of proof required by her argument that the defendant had engaged in intent to defraud. So it wasn't an announcement of the standard being applied. It was a reiteration of the arguments being made by the appellant. And that's a big difference. But secondly, even if the court had applied that standard, Given that it was invited by the appellants, both in their written submissions as well as in openings and presentation of arguments and evidence and closing arguments, that even if the court applied that standard and even if it was erroneous, it was completely invited by the appellants. So it's a complete invited error to the extent that it was an error in the first place, which again, we don't think it is. So I'm about out of time unless there's any additional questions from the panel. Thank you very much. We're asking the court, of course, to affirm the trial court's decision, finding that the appellant did not meet its evidentiary burden of proof to invalidate the Johns' marriage. Thank you.
Thank you, Mr. Cummings. Ms. DeGrave, 5 minutes. You are muted, Ms. DeGrave.
Thank you. Yes, a few points. First of all, and I think that this, the distinction really needs to be made. Mr. Cummings brings up the Metropolitan Dade County versus Shelton identifies defective applications, informalities in applications. That's not what we're talking about here. What we are talking about is a knowingly false application, a knowingly false intent to marriage. It was not just the use of the name Golene Davis. It was not Ms. Venetia Malcolm, who was born March 16th, 1947, whose parents have the last names of Malcolm, is never completed an application for marriage. The woman who did is Golene Davis, born March 6th, 1947, with Prudence Hilton as her mother and Cyril Davis as her father. Those are so many details that are clearly false and inaccurate and not applicable to Ms. Malcolm. She did not complete an application for marriage. Golene Davis completed an application for marriage. It is Golene Davis who completed the ceremony. So this is not just merely a defective or an informality in the application. This is a false affidavit, and it is the first step under Massachusetts law for a valid marriage is the completion of a notice of intent to marry. It doesn't matter that there might have been a ceremony if the first step wasn't completed, and the first step was an application for intent to marry, and Ms. Malcolm never completed an application for intent to marry as Ms. Malcolm with her correct biographical information. And then when you look at that, why would she use not just an assumed name, but also all of this other biographical information of a real life person? Why would she use that in the application for marriage? And then when you look at in her subsequent actions, and Mr. Cummings mentions, oh, well, it's years later. Well, regardless of when it was, time after time after time, it's over multiple years that Ms. Malcolm is continuing to enter into formal official documents filed with state governments that identify herself as a single woman. The Department of Massachusetts income tax form, it has 3 boxes. It has single, it has married filing jointly, and it has married filing separately. If she wanted to file a separate tax return, she could have filed married filing separately, but she didn't. She clicked single because she believed herself to be single. She was using the name Golene Davis and the resulting invalid marriage certificate to do one thing, and then so that she could continue to live her own life as a single woman and acquire property in her own name that was separate and apart from this. That is not an honest purpose. There is no reasonable interpretation of why she would use the biographical information of another real life human to obtain this marriage. So we're not talking about the sanctity of marriage that must be protected. We're talking about, let's call it for what it is. It was the use of a stolen identity to commit fraud on the Massachusetts government, but also to live 2 lives, to acquire property that could be separate and apart from her property as a single woman. As Mr. Cummings identified, we did identify as a secondary source, and we were not And we were forthright with the court that it was a secondary source and entitled to only to the persuasive authority that's there. We cited to that CLE article. The reason why we did is because you don't see cases like this, because this is just so out of the ordinary for this behavior that Ms. Malcolm engaged in. But the point is that Mr. John was not the spouse of Ms. Malcolm. Ms. Malcolm, through her actions, showed that she clearly did not think herself actually legally married. And so he was not the legal surviving spouse as that is required under Florida probate law. And so the order determining beneficiaries should be reversed and remanded with directions that the trial court find that Mr. John is not the surviving spouse and not a beneficiary of Ms. Malcolm's estate. Thank you.
Thank you, Mr. Grave. Thank you, Mr. Cummings. To leave our virtual courtroom, excuse me, click the leave button in the lower right-hand corner.